Hello, everyone. I'd like to welcome you all and thank you for coming today to this special meeting dedicated to legal English. I'm Francesco Maria Ricciardi. I passed the state bar exam and was appointed by the team of Diritto, to whom I am grateful for supporting me, to be your guide. I sincerely hope to be up to my task and wish you all enjoy my contribution. I'm going to give you a brief introduction to the history of legal English and its importance for legal practitioners. I think this could be interesting for you for both theoretical and practical reasons, and also useful as a preliminary lesson on the legal system in the United Kingdom, specifically in England and Wales, and in the USA. So, let's get started. Question number 1. What is legal English? It is a specialized variety of the English language used by legal professionals and in legal writing. This means that it is a specific form of English used for professional purposes in law and related contexts. As a legal language, it is formalized and differs from the ordinary natural language in vocabulary, morphology, syntax, semantics, as well as other linguistic features. This means that legal English has its own rules, and being a formal language, it could be difficult, even for an English native speaker, to understand the proper meaning of a legal document without a specific knowledge of these rules. Allow me to read these verses written by John Gay, an English poet and dramatist of the 18th century. I know you lawyers can with ease twist words and meanings as you please. Fair language, by your skill made pliant, will bend to favor every client. Pliant means flexible. The author thinks that the language spoken by lawyers is something artificial, unnatural, a sort of initiatic language by means of which lawyers rule the world and make words mean what they like. And this is one of the reasons why to study and master it. Actually, legal English is rather complex. Its vocabulary is very wide, made up of both highly formal, archaic words and foreign words mainly of Latin and French origin. It is characterized by verbosity, nominalizations, long complex sentences rich of passive verbs and embedded clauses. Embedded clauses are subordinate clauses. In legal writing, hypotaxis is more common. Moreover, the punctuation is used insufficiently. These are the main features of what is also called legalese, legalese. Legalese is an informal term which describes the traditional style of legal writing, also known as legal parlance, which is reader unfriendly, difficult for ordinary people to understand. We can also say that, in a certain sense, legalese is a pejorative term for abstruse forms of legal English. Let's take another look at literature, which is full of complaints against the abstrusity of legalese. This society, that of the lawyers, hath a particular cant and jargon of their own that no other mortal can understand, and wherein all the laws are written, which they take special care to multiply. Cant and jargon are synonyms. This is how Jonathan Swift in Gulliver's Travels lampoons the legal class. And this is one of my favorites. Fog everywhere. Fog up the river. Fog down the river. Fog on the Essex marshes. fog on the Kentish heights. Members of the High Court of Chancery mistily engage in one of the 1,000 stages of an endless course, with bills, cross-bills, answers, rejoinders, injunctions, affidavits, issues, references to masters' reports, mountains of costly nonsense piled before them. Charles Dickens, who worked as a legal clerk, often satirized the legal profession and the language of its practitioners. There, the author uses an effective metaphor, the fog, to describe the obscurity of their world. Both Charles Dickens and Jonathan Swift also sarcastically highlight the redundancy of legalese. But where does this complexity come from? The development of legal English is strictly related to the history of Great Britain, since it has been shaped by history, principally by major political, societal, and industrial events. To a certain extent, legal English is the outcome of a number of invasions of Britain. There are virtually no remnants of the legal language of the original Celtic inhabitants of the island. And as for the Roman period, this lasted from 43 BC to 410 AD. When the Romans had to leave Britain, their legacy was significant, but Latin, as a matter of fact, made little impression in Britain until St. Augustine's arrival to spread Christianity. In 450, Germanic tribes from northwest Germany invaded the island. They were the Jutes and, above all, the Angles and the Saxons. The Celts retreated to the west in Wales and in Scotland, while invaders landed in England. The language they brought with them forms the basis of what is also known as Old English. Some Anglo-Saxon legal terms have survived to today, such as writ, ordeal, witness, deem, oath, goods, guilt, manslaughter, omicidio colposo, murder, omicidio intenzionale, right, sheriff, steal, swear, theft, thief. The law, which reflected a more complicated society, used alliteration and conjoined phrases, a practice that to a limited extent still survives, as we can see, for instance, in to have and to hold, still used for marriage vows, or in residue and remainder, still found in some wills, or any and all, each and every, both beloved by lawyers. Christian missionaries who followed St. Augustine landed in Britain in 497 and introduced Latin. In this period, Latin words and phrases entered the legal language and still remain in current use, such as clerk, which derives from clericus, ratio decidendi, habeas corpus, affidavit, bona fide. The advent of Christianity also encouraged the use of writing, and this will have a considerable impact on legal English. Although Latin was incomprehensible to most of the population, it also enhanced communication at a time when there was no standard for written English. At the end of the 8th century, the Vikings from Scandinavia started raiding Britain and eventually settled down in the 9th century, bringing with them their linguistic contribution. Several thousand everyday words come from this period, including the word law itself, which derives from the Norse word for lay. thus it means that which is laid down. However, the Vikings' language didn't have a large impact on legal English. The invasion that had the biggest influence on the development of legal English, it happened in 1066 when another group of Scandinavians, the Normans, led by William the Conqueror, Duke of Normandy, so they came from France, conquered England. This event had a profound and lasting impact on the legal language, as Norman French became the official language of England, and for a period of nearly 300 years, it was also the language of legal proceedings. After the Norman conquest, as stated by Sir Walter Scott in his novel Ivanhoe, French was the language of honor, of chivalry, and even of justice, while the far more manly and expressive Anglo-Saxon was abandoned to the use of rustics and hinds, il vulgo, who knew no other. In this period, lawyers had to be trilingual in Latin, French, and English. Each language was used in specified domains. As for English, it was the spoken and living language of the majority of the population, but it wasn't used in legal matters. Law Latin was the language of writs, statutes, and court records until early 18th century. It was the preferred language when writing legal documents. Even the famous Magna Carta was written in Latin. But since only the learned were fluent in Latin, it never became the language of legal pleading or debate. The influence of Latin on legal English can be seen in the use of Latin legal maxims, such as caveat emptor, or in the terminology used for case names, versus, etc., ex rel, which is the abbreviation for ex relazione, or in the unusual word order in legal documents. This led to an ornate style deliberately used to impress rather than inform. French, which was the language of upper classes and of power, eventually became a language spoken only by lawyers, known as law French. It allowed a more precise communication thanks to its extensive technical vocabulary. There's a vast amount of basic legal terms deriving from it, such as parliament, appeal, attorney, court, defendant, evidence, judge, judgment, jury, justice, sentence, verdict. Another influence of the French language is that adjectives normally follow the noun they modify, a combination still common in legal English, as we can see in attorney general, or court martial, or fee simple absolute. Another trace is the creation of words ending in double E to indicate the person who was the recipient or object of an action, as in lessee, who is the person leased to. This is an example of how law French was used in legal writing. In this case, to regulate heritage problems. And there is the translation into current legal English. As you may infer, law French might have sounded rather bizarre to ordinary English speakers. Things changed in later centuries, as the use of Latin and law French for legal purposes gradually declined. Since the court procedures were in the French language, most of the population, the uneducated English people, could not understand the process. As a result of this, In 1362, the Parliament enacted the Statute of Pleading, which made it permissible to debate cases in English, although they continue to be recorded in Latin. Here it is. The statute condemned the French tongue as largely unknown in the said realm, which is the English realm, and required that henceforth all pleas be pleaded, showed, defended, answered, debated, and judged in the English tongue, and that they be entered and enrolled in Latin. Substantially, English should have been the language for oral communication in courts. But ironically, none of these English words can be read in the original document, since the statute, as you can see there and there, was written in French. And the class of lawyers seems to have largely ignored it in practice. Despite the conservatism of lawyers, wills began to be written in English in about 1400. Statutes were written in Latin until about 1300, in French until 1485, in English and French for a few years, and in English alone from 1489 onwards. The French lawyers became increasingly corrupt, and its vocabulary more and more limited, as demonstrated by the famous brickbat case in 1631. This was a case of a prisoner who, after his condemnation, as reported in Law French, threw a brickbat at the judge, missing him. The judge was not amused, and he ordered that the defendant's right arm be amputated, and the prisoner was immediately hanged in the presence of the court. This case is often cited to illustrate the severity of the law in former times, but above all to show the degeneration of law French in its dying stages, as demonstrated by the use of the English term brickbat. Lawyers were tossing in English words with abandon. In 1730, the final coup de grâce. The Parliament ended the use of Latin and Law French in legal proceedings with the Proceedings in Courts of Justice Act. English became the obligatory language for use in the courts of England and in the Court of Exchequer in Scotland. Time went by, and as the British Empire expanded, English colonizers transported legal English throughout their domains, including North America. Despite antipathy towards lawyers and English, the Americans maintained English legal language. The Declaration of Independence and the American Constitution are stylistically elegant and relatively simple, but in general, American legal language resembles that of the former colonial masters. This is true in other former English colonies, and that because, to a large extent, the retention of English legal language is closely related to the retention or adoption of English common law. People who adopt concepts from another culture tend also to adopt the words used to describe those concepts. The result of all the linguistic features and influences we have seen so far is a rich and diverse language with a complex grammar and many synonyms. Contemporary legal English can be divided into many sub-varieties according to the area of the law practiced. Each subgroup has its own characteristics, vocabulary, and multiple typical features. But in general, legal English follows very strict rules regarding its style, tone, morphology, level of formality, and grammatical structures in both its oral and written form. Despite its difficulty, one of the obligatory rules of legal English is its preciseness and clarity. The legal language cannot be vague, and ambiguity must be avoided since it can lead to negative consequences. But it is also necessary that the original meaning of that language be clearly perceived and understood by others. We will further analyze the main characteristics of legal English in the next meetings. In conclusion, we can say that it developed naturally under the influence of many diverse cultures and languages, along with the growing complexity of the legal system and the shift from predominantly oral to mainly written form of communication. That's all for today. Thank you for your attention. I hope you'll enjoy my contribution, my presentation, and see you next time.